Welcome to the deep dive. We try to, cut through the noise on complex topics. Today, we're diving into a really critical area of American law. It's this constant tension, this back and forth between individual rights and state power. I mean, our legal system is set up to protect the individual, to protect you. But, well, that protection isn't always absolute, is it?
No, definitely not. States have what the courts call legitimate interests, things like public health, safety.
Well, right, the general welfare. And sometimes those interests bump right up against individual freedoms.
Exactly. And that's where it gets complicated.
And that tension is precisely what we're exploring today. We have a very specific question framing our deep dive. Is it unconstitutional for a state to require physicians who perform abortions to have admitting privileges at a nearby hospital and for abortion clinics to have facilities comparable to an ambulatory surgical center?
It sounds technical, I know.
It does, a bit.
But it's actually a fantastic window into this bigger conversation about choice, dignity, and just how far government regulation can go. So our mission today is really to unpack the legal arguments behind this. We'll look at the key Supreme Court cases, track how things evolved, and really focus on how courts try to strike that balance, especially using this key idea called the undue burden standard.
The undue burden standard. Okay, we'll definitely need to unpack that. But first, let's set the scene a bit, historically. To really get today's question, we need to go back. And the starting point, for anyone familiar with this area, is usually Roe v. Wade, 1973.
That's the one, the landmark decision.
It established that a woman's right to choose is protected under the 14th Amendment's Due Process Clause, grounding it in a right to privacy. Foundational stuff.
Absolutely foundational. But, even Roe acknowledged that this right wasn't unlimited.
Right.
States could still regulate, especially later in pregnancy. So the immediate question became, well, how much regulation is too much? How do you balance the state's interest with this fundamental right?
That's the million-dollar question, isn't it? And things got, let's say, really interesting almost 20 years later. In 1992, with Planned Parenthood v. Casey.
Yes, Casey. A huge case.
Because Casey did something crucial. It reaffirmed Roe's core idea, the right to choose exists, but it introduced a whole new way of evaluating state laws.
Exactly. It threw out Roe's trimester framework and brought in the undue burden test. That became the new standard.
Okay, so define undue burden for us. What does that actually mean in practice?
Well, the court defined it as a state regulation that places a substantial obstacle in the path of a woman seeking an abortion before the fetus is viable.
A substantial obstacle, so not just any regulation.
Right. States could regulate abortion, they could pass informed consent laws, waiting periods, things like that, as long as those laws didn't create this substantial obstacle. The focus shifted from the stage of pregnancy to the actual effect of the law on access.
So it's about the practical impact on the person seeking the abortion.
Precisely. Does this law actually block someone's ability to exercise their right? That became the key question.
Okay, so we have Roe establishing the right, Casey refining it with the undue burden standard. Which brings us closer to our main question today. This standard needed a real-world test, didn't it? And it got one in 2016.
It certainly did. With Whole Woman's Health v. Hellerstedt, a major case dealing directly with those Texas laws you mentioned at the start.
Right, Texas House Bill 2, or HB2. Let's remind everyone what those key provisions were. First, doctors performing abortions had to get admitting privileges at a local hospital, specifically one within 30 miles. And second, the clinics themselves, the actual facilities, had to be upgraded to meet the standards of ambulatory surgical centers, or ASCs.
Which are often much more complex and expensive facilities.
Exactly. And Texas's argument was straightforward. On the surface, at least. They said these laws were about protecting women's health and safety.
A common justification for regulations in this area.
But this is where the undue burden test, as applied in Hellerstedt, really showed its teeth, right?
Absolutely. The majority opinion, written by Justice Breyer, looked closely at both parts of HB2.
And what did they find?
They found both provisions unconstitutional. They concluded that yes, these laws did impose an undue burden on women seeking abortions in Texas.
Okay, so how did they get there? What was the reasoning? Did they just disagree with the state's goal?
No, it wasn't about disagreeing with the goal of protecting health in principle. It was about the evidence. The court essentially acted like a fact-checker. They looked at Texas's claim that these laws would make abortion safer, and they examined the data.
And the data showed?
Well, the data showed that abortion in Texas was already incredibly safe before HB2. Complication rates were really low, something like 0.23% overall, maybe a bit higher, like 2.1% for Medicaid patients studied, but still very low.
So the problem the law was supposedly fixing wasn't much of a problem.
According to the majority's analysis of the evidence and expert testimony, yes. They found basically no significant health benefits from either the admitting privileges requirement or the ASC requirement. The existing regulations were seen as adequate.
Okay, so negligible health benefits, that's one side of the undue burden scale. What about the other side, the burden itself?
Well, the burden was significant and measurable.
How so?
The court looked at the real-world impact. These requirements forced a large number of abortion clinics in Texas to close their doors.
I remember hearing about that. The numbers were quite stark.
They were. The number of facilities dropped dramatically, from over 40 down to about 15, I believe.
Wow. Across a state as big as Texas.
Exactly. That meant women, particularly those in rural areas or with fewer resources, faced much longer travel distances, increased wait times. For many, these combined effects created that substantial obstacle that the Casey ruling talked about.
So the court weighed the two sides. The claimed but largely unsupported health benefits versus the very real, very significant obstacles to access.
Precisely. And the conclusion was that the burdens far outweighed any legitimate health benefits the state could actually point to. The court basically said, your justification doesn't hold up under scrutiny, especially given the cost of constitutional rights.
A very strong application of that undue burden test. But like many major Supreme Court decisions, it wasn't unanimous.
Not at all. There was a powerful dissenting opinion, particularly from Justice Clarence Thomas.
What was his main point of disagreement? Was it just about the outcome?
It went deeper than that.
Yeah.
Justice Thomas fundamentally disagreed with the way the majority reached its decision. He felt the court was overstepping its bounds.
How so?
He argued the majority was acting like a legislature, second-guessing the factual findings and policy choices made by the Texas lawmakers. In his view, courts shouldn't be reweighing medical evidence or deciding if a law is good policy. That's the legislature's job.
So a separation of powers argument, essentially.
Very much so. He also heavily criticized the undue burden standard itself.
Oh, what was his issue with it?
He suggested it's too subjective, too vague. He worried it allows judges too much leeway to impose their own views on abortion policy, rather than applying clear, objective legal rules. Consistency was a big theme.
Did he point to other cases where he felt the standard was applied differently?
Yes, he mentioned cases like Gonzalez v. Carhart and Stenberg v. Carhart, suggesting the court hadn't always been so demanding in its review of abortion regulations, or hadn't consistently prioritized protecting potential life in the same way. He saw an inconsistency in Hellerstedt.
And he also raised the point about treating abortion facilities differently.
Right. He questioned why abortion clinics shouldn't be subject to the same kind of health and safety regulations as, say, other outpatient surgical centers. He emphasized the state's legitimate interest in regulating all medical procedures.
So the dissent really focused on judicial role, the subjectivity of the test, and principles of federalism letting states regulate.
Exactly. It highlights a very different view of how courts should handle these disputes.
It really does lay bare that core tension we started with. Individual protection versus legitimate state interests. Hellerstedt feels like a perfect case study for that.
It absolutely is. And what Hellerstedt really drove home is that the undue burden analysis isn't just about the law's stated purpose, its intention.
It's about the actual impact.
The actual impact, exactly. Does it, in reality, create that substantial obstacle? A state can't just say a law is for health reasons. The court, at least in Hellerstedt, demanded evidence to back that claim up, especially when the burden on the right was so high.
And for you listening, this isn't just abstract legal theory. How judges interpret concepts like undue burden directly shapes people's lives, their ability to access health care and exercise rights.
The contrasting opinions in Hellerstedt really show these different philosophies about state power, individual autonomy, and what dignity means in this context.
It also touches on something lawyers talk about a lot. Stare decisis, following precedent.
Right, the principle of sticking to previous decisions. It's crucial for legal stability. But Hellerstedt also shows it's not rigid.
How so?
Well, applying a standard like undue burden inherently involves interpretation in light of current facts. The court in Hellerstedt looked at new evidence, the specific impact of these Texas laws. So while precedent guides, the court still has to apply it to the specific situation, considering the real-world evidence.
It shows the law isn't static, it has to grapple with current realities.
Definitely.
Now, obviously, this whole issue goes way beyond just the legal arguments in court opinions.
Oh, absolutely. These cases touch on deeply held moral, ethical, and political beliefs. The sources we looked at acknowledge that too.
And Hellerstedt really highlighted the role of evidence, didn't it? Medical data, statistics.
Hugely important in that case. The low complication rates were central to the majority's reasoning that the Texas laws weren't medically necessary to justify the burdens they imposed. It underscored how empirical evidence can play a critical role in judicial review, especially when health justifications are claimed.
Which makes you think, doesn't it? As medical science advances, particularly around things like fetal viability, how might that continue to shape these legal and ethical conversations?
That's an ongoing question. Technology and medical understanding are constantly evolving, and the law often has to adapt or reconsider its lines based on those changes. Viability was a key concept in Roe and Casey, and shifts there could certainly influence future debates.
Yeah, it seems like a discussion that's far from over.
Indeed. And while finding genuine common ground on the fundamental issue of abortion remains incredibly difficult, it is helpful to understand the different frameworks. You have perspectives emphasizing individual choice, autonomy, dignity, and others prioritizing state interests in regulation, health, and the protection of potential life. Hellerstedt showcased strong arguments rooted in both kinds of concerns. Understanding both is key.
So wrapping up our deep dive today on law, choice, and the undue burden, we started with the foundation in Roe v. Wade,
The right to privacy.
then moved to Planned Parenthood v. Casey, which gave us that crucial undue burden standard.
The substantial obstacle test.
And we saw how that test was applied really rigorously in Whole Woman's Health v. Hellerstedt, examining the actual impact of specific state laws,
Weighing the burdens against the benefits.
highlighting that constant push and pull between individual rights and state regulatory power.
Yeah, I think this journey really shows how these complex legal issues are rarely, if ever, black and white. Courts have this difficult task of weighing competing interests, looking at evidence, interpreting constitutional principles. It's a dynamic process.
Absolutely. So as you, our listener, reflect on all this, maybe think beyond just the specific legal outcomes we discussed. Consider those underlying principles. What really stands out to you about how a state claiming a legitimate interest can have such a profound effect on individual lives? And maybe ponder, how should courts best strike that balance between protecting individual choice and the undeniable power of state regulation? Something to think about.